Okay, let's go ahead and call to order the April 19th, 2017 meeting of the Longmont Planning and Zoning Commission. First order of business is roll call.
Commissioner Height. Commissioner Tedda.
Here.
Commissioner Check.
Here.
Commissioner Poland.
Here.
Commissioner Goldberg.
Here.
Commissioner Flagg. Here. Commissioner Bruneau.
Here.
Okay, next item, is there any communications from Principal Planner Don Pritchett? No. Next item is the public invited to be heard. This is the public's opportunity to come and speak before the commission on items that are not on the agenda for today. You'll be given 5 minutes up at the podium. We ask that you come up, state your name and address. You will be given, on the dais up there, you'll see a green light. At 4 minutes, it will turn yellow, and when your time is up, it will turn red. And I'm looking through the sheet here. And I have a couple names on here. The first one is Ruby Bowman.
Oh, yeah, sorry.
Hi, my name is Ruby Bowman, 1512 Left Hand Drive. I live in Longmont, and I'm here to speak about Longmont's wildlife, particularly black-tailed prairie dogs. I have lived in Longmont for about 20 years now, and in that time I've seen one after another prairie dog colony destroyed. There are a number of reasons for this, but we still should try to mitigate development's impact on our prairie dogs. In 2008-2009, city staff drafted a wildlife mitigation ordinance that established a protocol prioritizing non-lethal methods in dealing with prairie dogs on development property. First priority was to avoid impacting prairie dogs, then relocation, and as a final option, removal of the animals. The draft ordinance also established a mitigation fee when removal is done. The fee was based on the type of method used, and the fees collected were supposed to have been used for wildlife conservation purposes. And as you probably know, there is language in the municipal code that designates Longmont as a bird sanctuary. The draft ordinance would have expanded the sanctuary designation to include wildlife as well. The cities of Broomfield and Boulder have a prairie dog mitigation ordinance. I urge you to bring back the draft wildlife mitigation ordinance as part of your review for the Land Development Code update. Our prairie dogs desperately need your help. Also, please protect our wildlife habitat on St. Vrain Creek by keeping the 150-foot riparian setback for all sections of the creek. Not only does a substantial setback mitigate human-generated noise and light pollution on sensitive wildlife, but it filters polluted runoff from impervious surfaces from surrounding urban development. As you know, polluted stormwater runoff into streams and rivers is a real problem in urban areas. Longmont has only one St. Vrain Creek. Let's protect it for our wildlife and for people's enjoyment of a natural area. Thank you so much.
Thank you, Ms. Bowman. Next on the list, I believe it's Sherry Mulby. Did I get that right?
I have a handout. It's Malloy.
Malloy.
Good evening, Sherry Malloy, 2113 Rangeview Lane. I've lived and raised 2 kids and taught in Longmont for 31 years. Thank you for serving on this board. We're here to express future development concerns, which will be coming your way for approval along our St. Vrain corridor. The St. Vrain Improvement Project was spot on in its primary goals. One goal states, increasing capacity to protect people and infrastructure from future floods, making environmentally responsible approaches a priority by improving natural habitat for wildlife, fish, and overall river health by incorporating natural design, channel design techniques to improve the natural setting, end quote. This plan says keep the greenway green. Then there's the St. Vrain Blueprint Development Plan. Out there and then pulled for revisions, this will resurface with a new name. This plan is in direct conflict with the St. Vrain Improvement Project. Its goals are primarily economic. development is supposed to be approached as a three-legged stool, giving equal consideration to environmental and social impacts and economic impacts. In the pulled blueprint, our greenway's value was used as an enhancement to add value to private properties such as condos, breweries, and restaurants. 80% slanted toward economic development makes a very unbalanced stool. We're here to advocate that P&Z, at a minimum, hold firm to the required 150-foot setback that's in our land use code with no variances allowed. Last weekend, I spotted a beaver at Golden Ponds, a coyote, and 20 pelicans, 2 varieties, coming in for their majestic landings at sunset. What a treat. Making the green and greenway primarily about dollars will come at a significant cost to creek health, habitat, wildlife, and social value. Young families, and especially people of color, regularly visit our greenway. It's great to see kids enjoying wild and natural experiences they can't get in backyards or neighborhood parks. This experience is free for all to access with no cost and minimal travel. The human and property loss from the 2013 flood would have been much greater if more land was developed along this corridor. In February, the Army Corps of Engineers presented their feasibility study on the city stretch between the railroad bridge to Airport Road. As you see from the copy on their presentation I just gave you, there have been 10 recorded flood events since 1876 in this corridor. Common sense mandates that it's highly probable there will be another major flood event in our lifetime. Even with mitigation, it's unwise to develop any new properties in close proximity to the creek. The risk to humans, property, and taxpayers is just too great. The comp plan should be revised. Post-flood, Longmont residents want to restore the ecological integrity of this corridor. To have a wild creek running through the middle of town for all to enjoy is a precious gift that deserves to be preserved and protected. River walks with well-groomed landscapes are the antithesis of natural landscapes, which support honeybees, bats, voles, foxes, etc. We've got lots of well-groomed parks in Longmont. We have one St. Vrain Greenway. Let's keep it green. There are a handful of landowners and developers who are very invested and persuasive in influencing board members such as yourselves, City Council, and others to visualize and put in motion their development dreams. It's deeply concerning that so few have so much influence in shaping our corridor. These landowners have already seen huge increases in land value as flood mitigation plans remove their properties from the floodplain, allowing them to make even more money by developing land that previously couldn't be. Because of the huge public investment, $158 million and counting, how these properties might be developed must include serious expectations regarding minimizing environmental and social impacts. The Greenway belongs to the public. Because of the massive public investment, the public needs to have a significant voice in this plan. People love to walk and bike along the creek to get away from development. We've all walked along river walks and seen lots of buildings, restaurants, public art, manicured grass, shrubs, and potted flowers. It's a nice urban experience. What we don't see are cormorants, owls, muskrat, wildflowers, and natural grasses. These and more are regularly seen along our St. Vrain Creek. With development, this rich natural experience is severely at risk. With development, the wealthy will get much wealthier at the expense of the creek health, riparian habitat, birds, mammals, and people. It's a win-lose. We realize there is going to be new development on privately owned land. Indeed, there are already some commercial properties in close proximity to the creek. Landowners and developers asking for variances to the 150-foot setback will approach this board. We're here representing a growing number of citizens who stand with St. Vrain Creek and at a minimum expect this board to honor this required setback for any and all new development without exception. Bottom line is any new development along this corridor needs to respect and enhance our greenway, not exploit it. Thank you.
Thank you, Ms. Malloy. Next person, I believe, is Jamie Simo. Did I get that right? Sima.
My name is Jamie Simo, and I live at 525 East 16th Avenue. Thank you for the opportunity to speak tonight. As you are aware, the city is in the midst of work on its Resilient St. Vrain Flood Mitigation Project. The goal of the project is to not only restore the damage done to the St. Vrain Greenway by the fall 2013 flood, but to engineer the creek channel so that it is capable of passing 100-year flows of water, thereby reducing the size of the floodplain. While this project is necessary to protect homes and businesses in the path of future floods, I and many other city residents are concerned about the direct and indirect impacts of the project on wildlife that use the creek and its surrounding riparian area. The concern I bring up tonight is an indirect impact. According to the 2017 to 2021 Longmont Capital Improvements Plan, The Resilient St. Vrain project will remove over 800 acres of land from the floodplain. In reducing the size of the floodplain, the project will open up land for development near the creek where such development previously wasn't feasible. It is naive to think that property owners won't use this opportunity to build. However, I'm here to ask that you retain the minimum 150-foot setback from the St. Vrain, as established by the Longmont Municipal Code, for all new development and redevelopment, and that you not allow any variances to this minimum distance. Just within Longmont, St. Vrain Creek is home to wildlife, such as beaver and mink, and rare native fish like the stonecat. And it plays host to birds such as migrating spotted sandpipers, nesting bank swallows, a Boulder County species of special concern, and many songbirds. St. Vrain Creek also serves as a valuable movement corridor for wildlife traveling from the foothills to the plains. Last year, a bobcat and her kittens were captured on a wildlife camera set up at Sandstone Ranch. It's likely they traveled down from the foothills along the river to get to Sandstone. A family out for a walk last summer also spotted a black bear walking along the river in town, another likely foothills migrant. Due to increasing development, wildlife habitat is becoming progressively more fragmented. Allowing development to encroach upon St. Vrain Creek will fragment the habitat even further. With a growing number of businesses and houses comes a growing amount of noise and light pollution as well as more stormwater runoff, carrying chemicals like fertilizers and pesticides. Maintaining at least a 150-foot buffer between new and redevelopment and the St. Vrain is therefore critical to protecting this amazing and vital ecosystem. Thank you.
Thank you, Ms. Semo. That's it on the list. If there's anybody else in the audience who would like to come forward and say something to us? If not, at this time I'll go ahead and close the public invited to be heard. Next item on the agenda is approval of the minutes. We have 2 minutes to approve. Commissioner Goldberg.
Move to approve the minutes from the March 15th, 2017 P&Z Commission.
Second.
We have a first and second for that. Let's take a voice vote. All in favor say aye. 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 All opposed?
I have to abstain.
Duly noted. Okay. We also have the March 22nd. If somebody would like to put forward a motion.
I move to approve the March 22nd minutes from the Planning and Zoning Commission.
I'll second.
And we have a second on that as well. Once again, let's take voice vote on the March 22nd, 2017 agenda minutes. All in favor say aye. 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 All opposed? Okay. We are now on to the public hearing items. The first item on the list is Land Development Code Amendments, Short-Term Vacation Rentals, Senior Planner Brian Schumacher.
Thank you, Commissioners. So the Commission discussed this item on February 22nd, just to provide some preliminary feedback on different topics related to short-term vacation rentals, and I certainly appreciate all the input that the Commission provided at that time. And based upon that discussion, staff has put together a draft for the Commission's consideration this evening on the regulations regarding short-term vacation rentals. And it's 7:15 right now, and I know that Nancy Rizak from Visit Longmont is here. She has to leave in about 5 minutes for another meeting. So as part of my presentation, I was wondering if the Commission would just indulge a few brief comments from Ms. Rizak before she has to leave regarding the draft amendments. And I know that she had a board meeting this morning regarding the draft amendments, and she'd just like to make a few comments as part of my presentation as well. So if that'd be okay with the Commission.
City Attorney Kramer, no problem with this? Okay.
Good evening, Commissioners. My name is Nancy Rizak. I'm the Executive Director of Visit Longmont, and I come to you this evening on behalf of the Board and the staff at Visit Longmont. Today, at our monthly board meeting, the Board offered overwhelming support for the proposed amendments that Brian will present this evening. By developing a set of rules around short-term vacation rentals, the playing field will be leveled for our hotel partners. Owner-occupied and investment properties that offer short-term rentals will pay city sales and use taxes and participate in lodgers' tax collections. Visitors will still have a wealth of lodging options to choose from for their trip, and Visit Longmont will utilize any increase in funds to promote and market our destination and options to business and leisure travelers. Visit Longmont will work closely with the City of Longmont on implementation and administration of the proposed changes. While we are hopeful that we can attain 100% participation in the program, we understand that changes will take time to be absorbed. Visit Longmont is committed to provide the support that is necessary for the success of this program. I urge you to support the proposed amendments, and thank you for your consideration.
Thank you.
Thank you, Commissioners. So when we talked about this item back in February, staff provided some just kind of a look at in time in February about kind of what the rental market was in the Longmont area, surrounding area for short-term rentals. And this slide just provides kind of a snapshot. We talked a bit about that in February. Compared to some of the other vacation communities, destination communities in Colorado, obviously we don't have a high volume in terms of number of rentals currently. And you can see on this list, it's mixed between rentals of entire dwellings versus rentals of individual rooms in a dwelling or residence as well. And so as we drafted the regulations, we took that into consideration, and also the feedback that the commission provided in February with respect to which direction they'd like us to consider when drafting the regulations. As Nancy mentioned, with the board's support, we'll work with Visit Longmont and our staff to coordinate in terms of implementation of this program, assuming it moves forward and gets adopted, recommendation from the Planning and Zoning Commission, as well as adoption by City Council. But we'll certainly work with Visit Longmont in terms of the implementation and tracking of this program. And based upon the Commission's input in February, I think the overarching goal at that time was to try to keep it as simple as possible, not to try to weave in too many roadblocks in terms of trying to allow for vacation rentals in the community. Given the fact that we don't have a whole lot, there isn't a lot of concern about potential high concentrations of these types of facilities, at least at this time. So with that in mind, that was our goal, was to try to keep it as simple as possible. We've set it up in the draft as a 1-year temporary use permit that could be automatically renewed if there are no issues that come up with respect to for a particular rental, and then if the rules haven't changed during that time frame in terms of what the city's requirements are. Specifically related to the amendments, I'll just walk through those, and feel free to interrupt me if you have any specific questions. So consistent with, and most of these are consistent with Visit Longmont's original recommendations from last year. I think there's one deviation that we talked about in February with the Commission, and I'll touch upon that in just a second. One is that short-term vacation rentals will be allowed in all zoning districts where residential dwellings are allowed. They would not be subject to any type of separation requirement or any limitation in terms of the number of rentals that would be allowed in a particular geographic area. The maximum stay would be 30 days or less, consistent with industry and building code standards. And there would not be any minimum stay proposed at this time. So short-term vacation rentals of entire dwellings could either be owner-occupied or investment properties. And so when we talked about that in February, the proposal at that time, at least the discussion and the initial recommendation from Visit Longmont, was that it be limited to owner-occupied units. based on the discussion from the commission, and the suggestions was that there wasn't really seeing it that being an issue to allow both owner-occupied as well as investment properties to be considered as short-term vacation rentals. So that's how we've set up the draft. We've also included individual rooms that could be limited to, but those would be limited to owner-occupied properties. So you have a homeowner potentially renting out a room in their home on a nightly basis or a weekly basis or whatever that might be as part of this program. The rental occupancy would be limited to 2 persons per each legal conforming bedroom, and that was an item that the commission discussed. Staff had originally put out a suggestion that we try to potentially limit it, the occupancy to perhaps 6 or 8 for a dwelling, and the commission thought we should allow a little more flexibility with respect to the number of potential occupants depending upon the number of bedrooms in a home, so that, you know, for the experience of having a gathering with a group of family members, you might potentially have more than 6 or 8 members. So what we did in the draft was to put a limit based on each legal conforming bedroom within a home. And then we haven't proposed a cap in terms of the maximum number of rental days in the calendar year with respect to vacation rentals. 365. Depends upon whether it's a leap year. So then a few other items. No additional parking requirements associated with short-term vacation rentals. Obviously, they're intended to try to act as a single-family dwelling or a dwelling unit without creating additional impacts to the neighborhood. We did not, as in the draft, there's no exterior advertising signs would be allowed for short-term vacation rentals. And then they would be required to obtain a city sales and use tax license and also comply with our existing lodger's tax. And then finally is the discussion that we're going to have to make some amendments to the building code in addition to the land development code to allow for short-term vacation rentals. Now, right now, that's not really allowed in residential areas, less than 30-day rentals. So that's something we're going to have to work with building code staff on and work through some local amendments to the International Building Code. And if you have specific questions, I believe Jeremy Tamlin is here this evening from Building Inspection. If you have some questions about occupancy limits or requirements that may come into play for perhaps larger dwellings for either fire alarm systems or fire suppression. And it looks like one of the commissioners may have a question.
Commissioner Height, do you have a question?
I do. I had a couple. Again, Brian, thank you very much for this difficult and hard work. My questions are for you, though, not for Jeremy directly. No. If we're ready to entertain questions?
Yes.
Fantastic. Thank you. My first two questions are whether or not we regulate the number of bathrooms or the number of parking spaces for residential facilities. I mean, do we have regulations on, if a 4-bedroom house has to have 2 bathrooms, or is that just what the market dictates?
I'm not aware that we have, Jeremy, do we have, I don't believe we have minimum standards in terms of number of bathrooms that are required.
And then with respect to parking, do we have a minimum number of parking spaces required based upon the size of a house?
So for single-family residences, for example, detached residence, we have a requirement for a minimum of, I believe it's 1 off-street parking space. And then the intent is to have an additional parking space in front of the house as well, on the street.
And that's just for any residential structure, regardless of the size of the structure.
Yes, that's
Okay.
correct.
Because it occurred to me that if we're going to invite another quote-unquote mini family, or allow another two-person family to reside temporarily in a residential structure, we might be burdening restroom facilities, but possibly the market will take care of that. I'm a little bit more concerned with potential parking problems, and I know that the draft regulation proposes that there be no regulation on parking, but that possibly we might want to consider a complaint-driven standard that, sure, we won't impose a requirement, but if as this project blooms, to go with my metaphor further, the pollen of excess parking creates a problem, and we have sneezes, we might want to figure out a way to get that addressed. Secondly, in looking at the actual language of the draft of the ordinance revision, we use the word, it's a non-transferable permit. We don't use that in any other type of permit that's laid out in this particular section. Why are we worried about the transferability of this particular type of permit?
Well, when I was talking with our code enforcement staff, they were concerned, and it's maybe something we may need to address with other our temporary use permits as well. But they wanted to make sure that if it transferred hands, that the new owners would have to come in and get their own permit and make sure that they're following. Obviously, they'd have to apply for a sales and use tax license, and we want to make sure that they're following for and remitting taxes for the lodger's tax as well. So I apologize, Commissioner Height. I just wanted to clarify, for single-family, two-family duplexes, the requirement for parking requirement is 2 off-street parking spaces and 1 on-street parking space.
Okay, thanks. Does that have any bearing on whether or not, in your mind, if we have additional temporary residences, that changes the...
You know, a home that's not being rented out on a short-term basis, we don't have a limit in terms of how many family members can make up a family. You could have X number. I mean, you could have 15 or 20 members of a family living in a particular dwelling. So I think it's going to have to be potentially more on a complaint basis as opposed to putting down a specific standard in terms of number of parking spaces. Again, I don't think we want to have a person that's renting out their home to create a field of parking in front of their home that kind of detracts from the appearance of the neighborhood, more so than what the rest of the homes that aren't being rented on a short-term basis might look like. I don't anticipate a problem, but that's something we can certainly track and see if it becomes a problem.
Oh,
I'm bumping everybody, I apologize. I just keep turning it off to allow Brian to talk back. Again, non-transferability issue, to go back to that, if we put it in one clause here, it suggests that the other ones might be transferable, so maybe we put in a catch-all that says all of these permits aren't transferable unless there's something unique about this one. Commissioner Tennant, you had a brief exchange about the 365 number. That stuck out to me, too, for leap years. Every 4 years, 1 day a year is not going to be rentable. I don't know if it's an oversight. I don't know if I'm making a mountain out of a molehill, but you might want to think about that. And then lastly, my last question was, there's a new reference, at least I haven't been able to find a definition, to the PDSD. What is that? And now...
Oh, that's just an acronym for the Planning Development Services Director, Joni. And getting back to the comment about the 365 days, Originally, in an earlier draft, I was looking through the minutes from the February meeting, and there was some discussion about potentially limiting the number of days as opposed to not having a limit. So I put that in there kind of as a placeholder. So if the commission is okay with not having a restriction in terms of number of days, we'll probably just take that line item out.
Commissioner Teta.
Brian, I have a couple things. I guess I'm skeptical about the incentive for the owners to get the license. Is there anything we can do to try to encourage them? I wonder about maybe working to promote their properties through Visit Longmont. Maybe that would be a way to get them to sign up. I'm also not that I want to mimic what our neighbor cities might be doing, but I wonder if there's anything that stands out as being appreciably different than what Boulder does, for example. And is there a stick if they don't and they get caught? As far as the parking, I think for the most part HOA and covenants cover parking. They do in my neighborhood. I think anything we did might be redundant. But I think that's a really valid concern. I could see somebody, a dozen people, and they're all driving their own cars and parking in front of everybody's house. That could be a problem. It seems like the impetus to try to do all this, maybe, I'm just guessing, came from the hotel industry, and I feel like they're enjoying a really good time right now, probably not being impacted, although I could see maybe if things turn down, it impacting them. But I could also see this as a trend, maybe encouraging them to adapt a little bit. Hotels are seeming like they're changing, and maybe they could figure out a way to more nearly seem like a vacation rental instead of a Motel 6 sometimes, But.
Commissioner Bruno.
Yeah, Brian, I just have a quick question regarding the sort of licensing and the taxes and all that. I'm just trying to get an idea of like what sort of what that kind of looks like, and there may not be numbers associated with this yet or anything. I don't know. Maybe you can enlighten me a little bit more. But just for an average homeowner to go down and try to get one of these licenses, I mean, what are we talking about for like there's going to be some kind of a license fee, I'm assuming, right? And then basically the sales tax, the lodger's tax, all that has to do with if they actually get people in there that are paying. Is that pretty much kind of how it looks? And do you have any sort of a dollar amount for that initial permit?
So it's not an extreme amount, certainly. I think our sales and use tax license is either $25 or $50, and that's once you have that license, it's good for as long as you have your business. We'll be updating our application review fees as part of the Land Development Code update. So I don't know exactly what that fee will look like. But right now, for a temporary use that's longer than, I believe, 30 days, I believe it's $250 currently for a temporary use application. And we can certainly look at that, adjusting that if need be, if we figure out it potentially could be onerous to a property owner.
So just to follow up, so the temporary use permit would basically, if you're operating an Airbnb that goes more than 30 days of occupancy, then that would apply to you, or is that right? So
if you're renting a room or your entire dwelling for 30 days or less, you'd be considered a short-term vacation rentals. So the way we were thinking of setting up, the way it's drafted, is that it would be considered a kind of a longer-term temporary use, where we need an annual temporary use permit. But we thought that if a homeowner who's renting out their home or rooms in their home are in good standing, there hasn't been any code enforcement issues, and the rules really regarding short-term vacation rentals haven't changed, that temporary use permit would automatically renew, as opposed to having to go back through a process.
Thanks. I just have one more quick question. So the whole the part about the 2 persons per legal conforming bedroom, so I'm assuming that basically eliminates somebody with a 1-bedroom house or studio or something, that maybe they have a pull-out couch or something in the living room. They're going to be subject to that 2-person rule because it's not a conforming bedroom, right?
I mean, if they're renting out their entire 1-bedroom house, yeah, they could have 2 people there, okay, based on this.
All right. Thanks.
Okay. This is a public hearing item, so at this time I would like to go ahead and open up the public invited to be heard on this item. If anybody in the audience would like to come up and give us your comments on this, you'll be given 5 minutes. We did have Ms. Rizak, but she's already spoken. Seeing nobody moving forward, I will go ahead and close the invited public to be heard on this item and move this back to the commission for further discussion. Commissioner Flake.
Brian, I have a question on owner not being there. In other words, you're going to allow investment properties to become short-term rentals. So that would mean that, as I understand the term, that somebody from wherever could buy a house, turn it into a short-term rental, meet all of your conditions and the requirements, and never again see the house, or never see the house at all, and have it run by a broker or someone who specializes in short-term rentals, and the neighbors would never know who the owner next door is, and they could have a series of whomever going on in that house. Is that correct?
Yes, that's correct.
Commissioner Teta.
With respect to Janelle's comments, Commissioner Flake, I'm not sure how that would be any different than if it was a normal rental and somebody bought that house and rented it on a monthly or a yearly basis and never came here and never met any of the neighbors. Really, I'm struggling all the way around with the way we've got it in contradiction with what we can do in a hotel and in contradiction with what we can do in a normal rental situation. If you could rent in a hotel for a week, why is it wrong for somebody to want to rent for a week in a short-term vacation rental? If you can rent for a number of months or for a year in a normal rental, or stay in a hotel for 2 months, why would it be wrong or impermissible to want to stay or be able to stay for more than 30 days in a short-term vacation rental? I'm not seeing the distinction and understanding what it is about the short-term vacation rental that distinguishes it and makes it subject to different kind of restrictions.
I guess my concern, I'm sorry, you didn't acknowledge me, did you? I guess my concern would be that if it's owner-occupied, such as a bed and breakfast generally is occupied, then there is some kind of I mean, you're thinking about the surrounding neighborhood a little bit. In a hotel, somebody moves in and it's zoned for a hotel gets built, they sort of have no recourse, but yes, okay, yes, a hotel will be there. And however a motel, a hotel operates is what they have. But when you go to a situation where if you're renting a house for a short term and people move in to rent a house to live there, they're living there, and they get to know their neighbors, and that's what happens. If it's a short-term rental, I don't think the philosophy of the people staying there is quite the same, because they're not obliged to do any maintenance. They're not obliged to keep up the property. They're just using the facility. And so whatever happens, happens. I don't see the same feeling as somebody who, say, rents a house, which I know I have done, is rent a house, but then you're required to keep up with the lawn and whatever else that you obligate to do through that lease. I don't think that a short-term rental quite is the same sort of thing. And I get concerned about the neighborhoods that we do have having the same quality of life for the surrounding houses and the surrounding residents as they could end up with a bad value. Now, we have laws to shut them out eventually, and it takes time. We've had houses that have had to come under the police power of enforcement. But my concern is that existing neighborhoods have a right to have the quality of life that they have come to expect.
Commissioner Teta.
Not to belabor things, but I have to say, I did some work for somebody, a homeowner, this past week. The neighbor, while I was there, asked if he was in okay shape physically, because in the 2 years that he's lived there, he'd only seen him 2 or 3 times. The guy's an athlete, so he's in fine shape. But he wasn't maintaining the exterior of his home or his yard at all, not even close to what the adjacent homeowners were doing in a real nice neighborhood. And this is somebody who owns the house. So if we don't have, I mean, we have covenants and HOAs, which tend to be pretty restrictive, but if we don't have regulations that require people who own homes to maintain them at a particular level, to presume that because they're short-term renters that they're going to do something differently or be worse than, on average, any other demographic, I think is presumptuous, I guess. But
Commissioner Bruno.
I just kind of want to add something to what Commissioner Teta was saying. I mean, basically, I kind of look at things the same way. You know, a couple of years ago, I had a really horrible next-door neighbor that was a long-term rental for a year. And, I mean, I got to say, I wish that guy was short-term. You know, like I wish it was sort of like, if you get something bad that comes in there, it's like you're stuck with it for a week or a few days or something like that. Long-term rentals, I feel like, have more of a potential to be a real neighborhood nuisance than a short-term rental, but maybe that's just the way I'm looking at it, just from my personal experience. I've also stayed in Airbnbs for more than 30 days, verbos really. You know, I never understood what the issue was with that either, but it's a different demographic than the hotels. In my opinion anyway, I mean, if you eliminate the Airbnbs, everybody has to sort of be forced to stay in a hotel. Not that we're talking about eliminating it, but I just feel like it's a different demographic. It's something that, you know, the more open-minded we are about it, the better. You know, you can sort of see something that's maybe not as well known as a hotel and maybe get a little bit extra scared about the possibilities. But I'm with Commissioner Teta on a lot of this stuff. I feel like if we're going to have long-term rentals, I really don't see how it's that different.
Brian, I had a question. Getting back to what Commissioner Ted had asked about a stick. So right now, or let's say we move forward with this, and somebody does a short-term rental but doesn't go through the city to get the proper license, is there a penalty? And if so, what is that penalty?
You know, that would be covered through our penalties enforcement provisions under the Land Development Code, and Dan may be able to touch upon that from a legal standpoint.
Commissioner Pullen, we're working on updating the enforcement and penalties section as part of the code update as well. There are a number of methods the city has to enforce its entire land development code. even going so far as criminal charges if necessary. And we're working on streamlining that and making it a little bit more comprehensible. So if there is a particular enforcement mechanism you're thinking of that you'd like us to consider adding, that's good. But in general, the strategy is to have a number of possible enforcement mechanisms and apply the most appropriate one for the situation.
Okay, thank you. I just wanted to make sure that there was an incentive, whether it be a carrot or a stick, for them to get those licenses for the rentals. So that kind of covers my question.
I mean, I do like the idea of working with Visit Longmont in terms of opportunities to promote their properties, whether on their website or through some other link. I think that would be a good suggestion, that we could talk to Visit Longmont staff about that as an option.
Thank you. Commissioner Goldberg.
Hey, Brad. I got a really quick question. Number 6, I think Commissioner Hyde already touched on it, the limit of 2 persons per each legal bedroom. Did you confirm that if it's 2 adults and 2 kids, or 4 individuals, so what I understand is 2 can't be in the bedroom and 2 can't be out on the pull-out couch?
That's the way it's currently set up, but if the commission has some recommendations or suggestions, or if you have some questions, I don't know, Jeremy, if you have any input or thoughts on that?
Good evening. I'm Jeremy Tamlin, the Assistant Chief Building Official, Building Inspection Department. One item on that we would look at is if it's a legal bedroom or not, if there's a means of egress. So if it is a pull-out couch, then obviously your front door, rear door, you would have access to that. So building code-wise, that wouldn't be too much of an issue, except that in this situation they don't meet building code as a single-family residence as it is. They would have to be modified to comply with the International Building Code for commercial use, or you have amendments for our code.
I think I need you to repeat that or say it in a different choice of words.
It would be okay if we amend the code.
It would be okay. Yeah, I'm picturing like every Best Western or Marriott or Hilton, you get the 1-bedroom room, you get mom and dad are in the big room, and the kids or the brothers out on the couch. Seems fair.
So at the February meeting, I know there was some discussion about this. Some of the commissioners mentioned the notion of potentially limiting it by number of bedrooms. There is the option of kind of doing number of bedrooms times 2 plus 2 for example, if you have a pull-out couch. I mean, so for example, if you have a 3-bedroom, you could have 2 or 6 plus 2. That would be an option as well. So potential 8 on a 3-bedroom house. And
Commissioner Bruno.
Were you done? I think a lot of people, when they see that whole bedroom definition, usually has to do with a closet or something like that. I think Jeremy makes a pretty good point there. I mean, I think if it's a room with a pull-out couch that actually has egress, so safety-wise, it's going to be a safe place, but it's maybe not going to meet the qualifications for a bedroom as far as, if you're listing it on listing your house for sale or something. I think that would probably be a lot more appropriate and just kind of take care of the things we're worried about, and who cares if there's a closet or whatever.
Commissioner Teta.
2 things. Again, I feel like if I could have 15 people from my family come and stay with me at my house for a week, and I wasn't breaking any law or regulation, I'm not exactly sure how we can. It sounds really laudable. I understand egress and safety and all those things, but I'm not sure how we reconcile those two. The other thing is, I wonder if when we give them the permit, we could maybe provide them with some of the city ordinance information that we think is pertinent, noise and parking and things. Maybe they could be required to post that inside. Things that might keep those things from being issues.
Commissioner Height?
I think I agree with what Commissioner Ted is saying as well, which is that, how can we arbitrarily come up with a number? The problem is we kind of have to come up with a number, I think. And 2 persons per bedroom is, for me, a good initial benchmark. I know I've stayed in short-term rentals where, there's 1 bedroom with 2 sets of bunk beds for 4 freaking kids, 4 kids to stay in. And we don't necessarily have to go there right now. We can, this, is an experiment and can change as time goes on. But I think to start it out, I have concerns about parking. I have concerns about bathrooms. I think that 2 per bedroom is probably a reasonable place to at least start.
Commissioner Ted?
Yeah, I'm not going to disagree with you. Just as an aside, though, my daughter is living in New York City in an Airbnb situation. She's got 10 girls in a room with her. Just thought I'd mention that.
Commissioner Flake?
Commissioner Tedder, you need to send her money to get a bigger space.
She sends me money.
Yeah. So the situation, though, in a hotel room is, if we keep comparing it with hotel rooms, I'd rather compare it with bed and breakfast, a bed and breakfast kind of situation. But within a hotel room, there's a limited occupancy requirement, is there not? And so we need to have an official limit on occupancy. I've been in situations where, yes, there have been extra people, they bring in another cot, whatever. But if we don't have something that says, here are the minimum requirements of this kind of an operation, then it makes me incredibly uncomfortable. I'm already uncomfortable with the fact the owner is not there. But if there's kind of a way to post it, and I like Commissioner Tedda's idea about posting, here are the requirements, here's what you need to know when you're occupying this particular situation, that might make it easier to deal with. And then neighbors would know that the people renting or using the facility would know what the requirements are and what the expectations are. Because I'm certain in some neighborhoods people will just be up in arms over the situation, and we have to find a way to mitigate their issues as well, because they're already living there.
Commissioner Bruno?
I just want to quickly third that motion about the regulations being posted. I think that's a great idea. I feel like that will carry, a significant amount of weight when people go in there. And what we're afraid of, it sounds like, is people going in with a whole bunch of people and just having a huge party. And I think just having that, set of rules is probably going to make more difference than anything.
Commissioner Check?
Is it good to go?
Yes.
All right. Kind of changing topics back to the incentives to pay the city's tax, the lodging tax. I know services like Airbnb sometimes collect it on the city's behalf. Is that something that the city has looked into, or are we too small of a city to even qualify for such a thing?
Well, I know some of the larger metropolitan areas have approached Airbnb and VRBO, the larger vacation rental organizations, companies, and negotiated with them to collect tax. We haven't approached them because we have such a small number of rentals, and whether or not they'd be willing to consider that, but we could certainly touch base with them to see if that's something that they'd be willing to consider.
I didn't know if there was a formal way cities could do that, or if it was just a city-by-city basis, but yeah.
As of late, based on the research that we've done, it's been kind of on a city-by-city basis, working with primarily Airbnb and VRBO.
Okay, and, I'll just throw in my comments at this time. I see this as basically just a house. So when we talk about things about parking, about bathrooms, about those kind of things, we do not have limitations on those except what's already in the code. We don't have anything special about the number of cars that can park at a house. We don't know how many people are in a house. We don't know how many people are per bathroom in a house. I really don't care to try to get into the weeds about that. I like the way that this is written. It's pretty generic. It's easygoing. I know Commissioner Flake had an issue about the owner not being there. I've actually been in a B&B where actually the owner owned 6 or 7 different properties, and she was renting them out. So I don't have a problem with the fact that the owner isn't in the property itself. I like the way we laid this out. I think Commissioner Height mentioned, you know what, this is the first pass. In general, it looks like the rules are good. If something comes up along the way that needs to be changed, we can make changes to suit what we see happens. But as a first pass, I don't have an issue with the way that this is written. Commissioner Goldberg.
Yeah, I agree with most of what you said, Chairman Poland. The only challenge as I walk through the 10 amendments, the 10 proposed amendments before us, I can shoot them real fast. They're allowed in all zoning districts with residential dwellings, where residential dwellings are allowed, no problem. Not subject to distance separation requirements, cool. Stay could be 30 days or less, fine. No minimum. Either owner-occupied or investment properties, cool. Individual rooms would be limited to owner-occupied properties, okay? And then I'm down with all of them. The one that I just have trouble with the most is number 6, which is the limitations of 2 per bedroom. And you're right, in a normal home, maybe there's not regulations on how many folks will be in that house, and maybe Brian never knows how many people are in a home. But in this case, I do think there was a fair solution proposed, which was a 2-person per bedroom plus 2. So if there's 4 bedrooms, let me do the math real quick. So if there's 2 bedrooms, it's 4 adults plus 2 on the couch. If there's 3, it's 6 adults or 6 people plus 2 on the couch. And I wonder if that would just make this more lasting and more amenable to the intent, which is for folks to be able to get affordable housing options in our cool town.
Commissioner Teta.
Yeah, I like that fine. I just, I wonder, would the renter be subject to a late-night raid where, the authorities came and counted the people in the beds and made sure that there weren't 1 or 2 too many, and it just seems like maybe we could be doing more important things. That the market might regulate that, just like when you rent a houseboat on Lake Powell.
Brian?
I think our job here today is to do as good of a job as we can to get to the most effective and functional wording on the paper. So I don't know if Commissioner Teta is suggesting that we remove 6 altogether and put no limitations, but my suggestion would be that we modify 6 to include a plus 2 per bedroom. 2 per bedroom plus 2.
Any further discussion, comments? Would somebody like to put forward a motion? Commissioner Flake.
I would propose a motion PZR 2017-17B with the condition that in each such short-term rental dwelling that like a hotel, that the rules and regulations are posted where those staying there can readily see them.
Commissioner Height.
I'd like to propose to Ms. Flake, or to Commissioner Flakes, additional conditions to proposal B, that the two more proposals be suggested, which is that the number of the number of occupants be limited to 2 per bedroom plus 2, as we discussed. And I would also like to propose a potential cure for my view of a potential problem with parking, which is that the rule, subsection I, which says that there's no additional off-street parking is required, that be conditioned upon there being no complaint, or said conversely, that if there is a complaint, that the PDSD reserves the right to impose future off-site parking requirements to address said complaints.
Brian, currently, if you have a residence where you're getting complaints from other residents that there's too many cars being parked there, what happens? What happens in the normal realm right now?
Well, I suspect our code enforcement staff would go out and see if all the vehicles are adequately licensed and registered first. And then, they may inquire into, with the occupants into the home of, who's all living there. Because we do have, by our code, there's a definition of family that allows up to 5 unrelated individuals as part of a family to live in a dwelling. So, I guess we could check to see if that standard is being met for a particular dwelling. And if it isn't being met, then perhaps, some of those vehicles would need to be moved if they're...
So in Commissioner Height's example, if there's somebody renting a property and they are abusing the parking spaces and neighbors complain, then the code enforcement would be sent to evaluate the situation?
I believe so. I guess if they're parking in the garage, if there's space in the garage, first of all, and they're parking in the driveway and they're parking legally on the street in front of that particular house, I don't anticipate there being a particular issue. Now, if they're parking on the lawn, or if they're parking, I guess if they're parking elsewhere on the street in front of the neighbor's house, they've had a large number of people bringing their own vehicles as opposed to a family arriving with 1 or maybe 2 vehicles. That may be cause for concern. I'm hoping it doesn't come to that, but that's something we'd have to ask code enforcement to go out and take a look at on a case-by-case basis.
Commissioner Teta.
Having lived in New York City, where you don't have the luxury of having frontage necessarily on your property, and buildings go up, and there's alternate side of the street parking, for example, where you have to get out and move your car to a different side 2 times a day at midnight and at noon, and you're almost certainly not parking in front of any place that you live. Mm-hmm. I think unless we want to go like Boulder to RPP type stuff, where you have residential parking permits, so only people who own that dwelling are allowed to park on that street. In Boulder, that's to keep students or employees from parking in front of people's homes, but they then get stickers for their car. I'm not saying I want to go there, but I have 4 kids, so my wife and I and 4 kids, they can't all quite drive yet, but we could have 6 cars, no problem, and I cannot put 6 cars in my driveway and in my 2-car garage. So my HOA and my covenant prohibit on-street parking, but what else would I do? But that's an HOA and a covenant. That's not a city ordinance. We don't have any maximum number of cars on a street or maximum number of cars that are attributable to a particular residence ordinances, anything like that. So if somebody complained or there were multiple complaints, while I feel like that is a really good place to start, they would have to be supported by a city ordinance. If it's just somebody saying, hey, there are too many people and they're parking in front of my house and there are too many cars, but nothing illegal is going on, then how do you regulate that? You just say, well, they don't like it. Your neighbors don't like it. You know.
Commissioner Flake, back to you, and we do have your motion.
I understand that. I'm speaking against the parking requirement because we have public streets. As my understanding, anybody can park any place on a public street and not move their vehicle for what, 72 hours or 36 or whatever that amount of hours is?
Yeah, I believe it's 72 hours, but I'd have to double check on that.
Commissioner Flake, I think technically it's 24.
Well, all my kids are in violation then.
Commissioner Height.
My only point is, Commissioner Teta, is that, heaven forbid, I live next to you and you had 6 cars and you were parking on the street and then you were going to get into the temporary short-term rental market and now there's a 7th, possibly an 8th car out there, I might want to complain. This regulation is drafted guts my ability to have a complaint about. I don't think I can necessarily complain about your 6 cars, but your 7th and 8th car that are there because of your short-term rental, which we are now voting about whether or not to adopt. I'm saying, as I think we owe a duty to the rest of the residents of the city to have a tooth that they might be able to bite back with if it is a problem. And again, how you define that, what is the complaint, what's the basis of the complaint, you got to put some teeth in it, I think. If there's a potential that there could be a problem, at least I see that there's a potential to be a problem. And so that's, again, I've beat this to death. I think we need to have a complaint-based ability to have the parking addressed if it ever becomes a problem.
So if I could just interject. So not specifically to the highlighted items regarding short-term vacation rentals, but on page 4 of the draft changes under the general standards, under D2, that's on parking, it says the use shall provide adequate parking area and improvements either on site or at an alternate locations to accommodate anticipated vehicular traffic. I mean, I think that's a situation where if we have this as a temporary use permit, that if we have ongoing complaints associated with this use, that there may be a situation where that temporary use permit doesn't automatically renew. We have to address that with this particular homeowner that we've continued to receive complaints either about parking or noise or whatever that might be.
Commissioner Teta.
What about, do we have any municipal parking within the city that we could offer as an alternative? Let's say a short-term rental might be bringing 10 or 12 cars. Could we say that's not going to work, but we have someplace you could park, and it wouldn't cost any chance something like that? I mean, otherwise I just can't see anybody, especially without there being an actual city ordinance, really paying much heed to our recommendations or a loudmouth neighbor.
Commissioner Bruno.
Yeah, I mean, I'm a little bit, I feel like what Brian just described seems like it would take care of this problem enough for my personal satisfaction on this. I'm not sure, like there's been a couple motions thrown out here, but I'm personally in favor of the 2 per bedroom plus 2 amendment, and I'm personally in favor of the posting of city ordinances that we feel might be violated by the short-term rentals. And other than that, I feel like it looks pretty good.
Thank you. Commissioner Flagg. It has been mentioned that there's a second motion that or a second amendment people would like to make. So since you have the proposal currently stated on the floor, would you like to amend it to add the second condition?
Let us so do that then. And do you want me to come up with the wording?
The +2.
Change the occupancy to allow for 2 per bedroom occupancy plus 2 more adults.
Oh, no, 2 more.
2 per bedroom plus 2 more adults.
Yeah.
Well, but it could be children.
Well, you said adults before. You want it now.
Oh.
People then.
People. I think
Commissioner Poland, I think I understand. So there were 2 conditions. The first one being about posting
rules.
The rules. I assume staff would figure out which rules the rules are that would need to be posted. And the second one being modifying the proposed standard of 2 occupants per bedroom to add an additional 2.
2 residents per bedroom plus 2.
Yes.
Okay. We have a motion on the floor.
I'll second.
We have a second. Is there any further discussion, comments? Commissioner Goldberg?
Yeah, I'm going to support this motion. I appreciate Commissioner Flagg's nimbleness and ability to modify her motion, and I do think allowing the +2 will make this more attractive and timeless document. In relation to Commissioner Height's concerns about parking, as always, Commissioner Height brings ideas to the table that challenge me, and I suspect and I hope that the teeth that Commissioner Height was looking for can be found in that section D. Where'd it go? D. Hold on. D. Was it D2 regarding any temporary permit requiring adequate parking either on site or at alternate locations to accommodate anticipated vehicular traffic. And if that's not being met and there's complaints, then our enforcement team can deal with that.
Commissioner Height.
I think Commissioner Goldberg just addressed, which was exactly where Mr. Schumacher had, or where Brian had been identifying where the parking requirement was, and I do now see it in D2. Thank you.
Any more discussion? If not, let's take our vote. And that does pass 7-0. This item will now be forwarded to the Longmont City Council for action. If you are unfamiliar with council procedures and intend to appear before council, please contact the Planning Division for further information at 303-651-8330. Okay, we're ready to move on to the next public hearing item. That is number 7, Land Development Code Amendments, Temporary Itinerant Uses. Senior Planner Brian Schumacher.
All right, well, thank you, Commissioners. So I want to preface this discussion with some new information that we received today. It's at your places. I don't know if you've had a chance to look at it. If not, you might want to take just a brief moment to peruse that. I can preface it and just summarize. It's some information that was submitted to us by Mike Schnatzmeyer as well as Scott Converse. Mike Schnatzmeyer spoke briefly to the commission in February, and then he followed up with this information today. Mike has been involved with both Startup Longmont as well as Tinkermill Makerspace. He's also involved with other interests in the community. And then also Scott Converse is also one of the co-founders, and I think he's currently involved with the Tinkermill as well. And both Mike and Scott have requested that the commission not move forward and take a formal action tonight on this particular item. They would like to organize a meeting with representatives from Startup Longmont, the Tinkermill, and other interested parties to meet with staff to talk about options for encouraging or creating opportunities for startup businesses in the community. And that may tie in with the temporary use provisions with respect to short-term rental businesses, either retail space or office space or whatever. And, you know, they provided a few links to a variety of sources, and we can send you the documents with the live links, obviously. You can look up that information as well. Somewhere on here, I pulled up, I don't know if I have that quite right. Bear with me for a second. I thought I had it up. So in Mr. Converse's comments, he had a link, and I'll get back to the presentation here for a moment. I'm going to just open up this link. So this is just a few examples that ideas that some other communities are taking a look at with respect to temporary pop-up businesses for startup type of businesses using containers, shipping containers as one idea. And so these are just a few examples of businesses that have been used either on a very short-term basis or a longer temporary basis to try to encourage new startups in the community. And so they're requesting that the commission not take final action on this item this evening, but I would, taking into consideration their suggestions, would like to meet with them and our staff, and both from a standpoint of not only zoning but also building code requirements and other municipal requirements associated with these types of facilities and how they may or may not be able to be accommodated, either under our current standards or with amended standards. That said, obviously we put together some drafts based upon input and discussion that the commission had in February. I would still, this evening, like to get any thoughts that you have on some of the draft language that's in your packet, in addition to any thoughts you have regarding these comments that are provided to you this evening from Mr. Schnatzmeyer or Mr. Converse. So, that said, I'll go back to the presentation part. So, and I'd like to maybe turn it back to the commission just for a second and see what your thoughts are with respect to kind of holding this item over to allow staff time to have a discussion with these groups about opportunities for encouraging startup businesses. I will say, and I think I mentioned this briefly in the communication, that I know this is something that I've talked to Kimberly McKee, the executive director of the DDA, for the downtown, particularly some of the areas, perhaps the area south of 3rd Avenue, where there's some older industrial areas where there might be some opportunities for looking at temporary uses for startup businesses. Other ideas might be utilizing vacant storefronts for some type of pop-up businesses as well. And so we've, with the master plan update that the commission just reviewed last month for the downtown, that's one thing that was brought up as part of that master plan update for the downtown as well, is looking at opportunities for encouraging additional small businesses and startups in the downtown area as well. So I'd be happy to walk through the amendments that are in the packet and see if the commission has any initial thoughts or reactions to those in addition to this request. But I would like to kind of see how the commission would like to proceed on this matter.
Commissioner Flake?
Well, Brian, given the choice, I think I'd like to see that meeting occur, because I know I commonly say things, probably not here on the commission, but I always note that we in this country don't have a very good track record of effectively reusing things. We just continue to expand, or we tear down, and we don't try to have any effective reuse policies. And if we're going to really push resiliency and sustainability and those kinds of things, perhaps this is a first step of acknowledging that effective reuse of materials that already exist would be a viable thing to do. So I would support basically shelving this and seeing what you do with the meeting.
Commissioner Bruno?
I think Commissioner Flagg just made a really good point that I'd like to maybe show support for. And I just want to say that, if staff, a lot of times when these things, whether it's a building proposal or whatever, sometimes you get that feeling like, maybe this hasn't been completely thought through, or maybe there hasn't been enough time to really hash something this complicated out. And if staff in their wisdom think that, this is worth listening to, I certainly would support tabling it until they feel that they've heard as many angles on this as possible from the parties that they feel are going to provide really good input.
Commissioner Height?
Yeah, Brian, I just wanted to confirm that you would value a meeting with Mr. Converse and, is it Schnatzmeyer? You would.
Yeah, I think it would be helpful and worthwhile. I mean, obviously, they would like to provide some thoughts and input and ideas behind this notion of, kind of short-term or longer-term temporary use. Mr. Schnatzmeyer points out he has some concerns regarding some of the restrictions in the current draft in terms of either the number of permits allowed for kind of short-term retail uses or the length of those permits. And, I'd like to get their thoughts on that, of how they feel that those types of startup businesses could be, allowing that to happen, but still being adequately regulated. So perhaps it's not just a free-for-all, to the extent that regulation is needed. But that said, I concur. I think it would be a good idea. I mean, I think, Mr. Schnatzmeyer, Mr. Converse, and perhaps others from Startup Longmont and the Tinker Mill and others that are interested in promoting startup businesses in their community. I think even if the commission were to forward this on to council this evening, I think they would bring this matter up in front of city council. We'd probably have to look at it anyway, so I think it's worthwhile to take a look at it. I still would, if you have any margin notes or questions or comments about the current draft, absent the discussion that we might have with the startup Longmont group and the Tinkermill group, any thoughts you have regarding the current version of the draft about expanding allowances for additional temporary itinerant uses, either in terms of services or retail uses or mobile vendors? If you have any thoughts or concerns about that or questions, I would certainly appreciate getting any feedback this evening if you have any thoughts on that as well.
I have more. I'm certainly prepared to, I'd love to share with you some of my thoughts that I have, but then I have as a bigger question for you, Attorney Kramer, which is from a procedural standpoint. My understanding was that this matter has been properly noticed and it is up for our review tonight. Can we punt and allow additional comment to come in this way?
Well, if I could just interject before Dan gives a legal opinion. I mean, I think that, obviously it has been noticed as a public hearing. I think we'd want to open the public hearing. If there's anybody in the audience that would like to provide any comments this evening and close that public hearing. And then if the commission, they have the option of not taking any action on this particular item, or they could continue it to a date certain. Whatever your thoughts are. My suspicion is that a meeting with, as suggested by Mr. Schnatzmeyer, would probably be a week or two out. I'm not sure if we'd be able to bring this item back for the May meeting, or it may have to occur in June. So I'm not sure exactly what that date might be.
But it does. My feeling is this is an urgent issue. So for us to get it right, I don't mind taking a month or two onto the time. So,
just to respond to Commissioner Height's question, I agree with everything Brian just said. I think that one difference here is that because this isn't a quasi-judicial matter, there wouldn't have been notices to any particular property owners in the mail. It would have just been noticed as a general public meeting, public hearing item, or not necessarily even a public hearing item, but a public meeting. So it is possible to continue it to a date and time certain, but I don't think that's necessary. Renoticing an item like this is really not that big of a deal compared to a quasi-judicial item.
okay. At this time, actually, let me go ahead. This is a public hearing item. I'm going to go ahead and open up the public hearing, invited to be heard. So if somebody in the audience would like to come up, you'll be given 5 minutes to speak to us with your opinions on this item. Nobody was on the sheet. If anybody else would like to step up, I'm not seeing anybody step up, so I will go ahead and close the public invited to be heard on this item and move it back to the commission. At this time, does anybody in the commission have any questions for Brian regarding the current version?
I asked a question last time. I was just curious if we could have a map maybe that showed where, for example, the 250-foot from an existing restaurant, brick and mortar restaurant, if we could see, are there actually any places where a food truck could operate, given that, that'd be a nice thing to have.
Just in response to that, yeah, I believe when staff worked on the food truck amendments, I believe we did do some mapping on that, and we can try to resurrect that and bring that. We did, as an amendment to that, originally there was a 250-foot requirement with no possibility for waiver, and then we did a subsequent amendment to that to allow if the food truck or food cart owner were able to get sign off from all the restaurant owners within 250 feet, then they would be able to locate closer than 250 feet. So that was an amendment that was put in place.
Commissioner Height.
Two questions. Following on to the food truck issue, why would we not permit food trucks in a residential area where they might meet with their most success?
I know there's an exception for ice cream vendors, and that's been in place for a long time in the code. But, when the original food vendor provision was put in place, it was restricted to non-residential areas. I didn't work on that specifically, but I'm guessing there was potential concern about just impact to residences and residential areas if you have food trucks traveling up and down, single-family neighborhoods. There may be a way to address that. I know we actually had somebody approach us today about whether or not they could do a food truck at a construction site in a residential zone, and we had to tell them no. Well, you can't under the current standards. So we may be able to, we could certainly look at that if there's an interest on the part of the commission to potentially look at allowing more flexibility with regard to that provision.
Again, the prospect works, and that's right smack dab in the middle of a mixed-use PUD area, which has its own special permitting. I understand that, but that model seems to succeed. My second question is, what's a garage sale as an itinerant use or not an itinerant use? Somebody's residential garage sale.
So again, garage sale isn't really covered under the Land Development Code temporary use provisions. That's under a separate permit under the municipal code. So garage sales or yard sales aren't really addressed in this section. Yes.
Commissioner Goldberg.
Hey, Brian. That was a provocative question brought by Commissioner Height. I, too, am leaning back wondering about the food trucks' access into the residential area. But my question lies in something far more trivial, and that is Christmas trees. Churches are oftentimes located around residences, but maybe they're not in residential zoned areas. Like, what sort of properties are churches allowed on, and can they sell Christmas trees on churches? At churches.
Well, most churches are in residential areas.
They are.
More and more you're seeing some churches go into vacant commercial space, either on a temporary basis or a longer-term basis. We've seen that some larger churches in other communities where they've leased out space in vacant shopping centers. So in that sense, churches that are in residentially zoned areas, they would not be allowed to sell Christmas trees. If a church was in a commercial shopping center, then potentially they could.
Have you ever had a request from a church to sell Christmas trees?
Maybe indirectly as a nonprofit group that's setting up a tent with on a commercial lot and selling Christmas trees, and whether that's a church group or some other nonprofit. Typically, the Christmas tree sales are either nonprofits or there's, a few Christmas tree companies that launch out during the season and sell a bunch of Christmas trees. So.
Well, I'm not here to fix something that ain't broke, but I could see the potential or the interest of a church to sell Christmas trees, and I wouldn't have any objection to that as it relates to the code before us. So when it says under locations permitted, seasonal and holiday sale activities shall be permitted in all non-residential zoning districts, including PUD mixed use, I just wondered if if there's any interest in allowing seasonal and holiday sales to be in residential zoned areas.
Commissioner Flagg.
Yeah, that is a quandary kind of a question, because sometimes church groups sell fireworks, and I don't want those in a residential area. It's I live across from an uninhabited commercial area, and the fireworks that they sell there and the noise and all of the other stuff that goes with it is enough already. Just saying.
Commissioner Teta.
We go out of our way to patronize nurseries when we buy Christmas trees. Blue Ribbon Farm or Yada High is where I bought the last 2 years. Those are licensed businesses, retail licenses. I personally don't see any need for a Christmas tree purveyor to set up shop in a vacant lot on a corner in a residential or a commercial part of town. I'd like to prohibit Home Depot and King Soopers from selling them too while we're at it. But
Brian, I have a question on E3C. Number of other temporary retail sales permits. The city shall limit the number of permits for other temporary rental sales to no more than 12 per calendar year. So is that per person? Or is that just, the city's just going to give out 12 in a year and that's it?
So, when we chatted in February, so that is just citywide, that's 12. So that's a limit citywide for the calendar year. So, I gave a few examples in February about, the hot tub sales or, whatever that might happen in terms of, occasionally we'll get somebody wanting to do a larger or smaller scale sale outdoors at a location. It doesn't happen very frequently. And I know some of the commissioners in February had some concerns about having a potential proliferation of outdoor retail sales in the community. And so this was just a first blush attempt at trying to limit it not only by the number of permits that would be issued, and then we kind of see how that plays out and adjust it as need be, but also put a limit in terms of how long those retail sales could occur, and that was 3 consecutive days. So,
Commissioner Teta.
it makes sense with retail, but for example, if there's an event in Roosevelt Park, I'm guessing you have to get a permit to be able to sell to retail beer from a stand there. Can anybody see anything being served by limiting that to 12 per year? What if they wanted to put 16 events on in multiple locations that were in conjunction with the city that seemed like really great ideas, but something had to be retailed? Would that have to go before the city council for a special exception? Or
So, yeah, it's one thing I didn't include in there is that we may want to put in some type of exception for special events, because typically that goes through a separate process. For example, a special event at Roosevelt Park or whatever that's put on by the city or an organization that's gone to the city to organize a special event that's kind of more of like a community-wide event.
Any more thoughts on this? And I think if we want to move this to a date uncertain, we would have to make a motion.
Dan said we didn't need to pick dates.
Chair Poland, I think you have a few different options at this time. The simplest might be to just do nothing and not pass any resolution with regard to this item, expecting that staff will bring it back. There could be a motion to table the item, and then you could pull it back off the table when staff was ready to bring it back. That's also fine. You could also postpone it to a date and time certain. You'd be picking a date and time that might or might not end up being the right date and time. Those are the 3 options I see.
Brian?
I would suggest option one of just not taking any action. And we'll bring it back when it's ready.
I move that we table this item to a date uncertain.
I would second that.
Okay, we have a motion and a second to table this to a date uncertain. Let's go ahead. And is there any other discussion on this item? If not, let's go ahead and take a vote. And that motion passes 7-0, so this item has been tabled to a date uncertain.
All right, thank you, Commissioners.
Thank you. We are now over to other business. Final public invited to be heard. If there's anybody in the audience who would like to come up and talk to the commission about an item that was not on today's agenda, you have your 5 minutes of time to talk to us. Seeing nobody moving forward, I'll go ahead and close the final call public invited to be heard. Items from the commission.
I just had one thing. We don't typically get people speaking about items that are not on our agenda, and we had 3 people come out tonight and talk about riparian setbacks and 150. I think the 150-foot distance is arbitrary. I think that's something staff came up with. I'm not trying to discount it or say I want to ignore it, but it'd be, I wonder if maybe language could be a little different, like that 150 feet be something we strive for, or that when it's, when we're putting some retail development right there, maybe we think about that beforehand, so we don't need to be having variances about how close we're getting to our St. Vrain Greenway. I mean, I feel like the St. Vrain Greenway is something we did create for the purpose of dovetailing with commercial and a river walk and a path, and so it's not as clear cut as maybe they made it out to be. I think the portion of that St. Vrain Greenway upon which there's the potential for encroachment is really small when you think about how much distance that St. Vrain spans. But I don't think we need to be going out of our way to get really close to it either. But I wonder how much of it's natural, I mean, and what natural even means, because a flood takes a river and moves it, and now that's natural. So what actually was it? The fact that we're widening it or digging it out, is that a bad thing? The river does that to itself, and that's okay, but we're not allowed to use earth-moving equipment. I'm not sure. I appreciate the concern for all the wildlife and stuff along it. I had a question about the prairie dogs, though. We a couple of times recently we have tried to have prairie dogs relocated. Nobody took us up on it. It doesn't surprise me. I don't know who's out there trying to take itinerant prairie dogs in, but so I'm not positive what the city how we feel like that's going to be working, but some people care about them. So since we have that in place, we're not killing them, we're relocating them, and then if there's nowhere to relocate them to, I'm not sure that that's that effective. But there are tailings sometimes, like Left Hand Creek. I remember when we were talking about over in Michael and his neighborhood, and it wasn't really Left Hand Creek, it was a tailing. And so we still have that same 150-foot riparian setback, even though it's a tailing from the creek. I wonder how, who is it that's making those? Is it the Army Corps of Engineers that gets to make those determinations? Is it just whoever happens to be in that spot on city staff that day. I don't know.
Don, you have some feedback on this?
I'll try. They're all good questions. So just to refresh everybody on what we do when we have an applicant who comes in and has prairie dogs on their property, the first thing that we are doing is we're asking them to reach out to the people that we know would have knowledge of relocation sites, which would be the Colorado Parks and Wildlife people, Boulder County, Parks and Open Space staff if they're in Boulder County, Weld County folks if the property happens to be in Weld County. And then we ask them to also just kind of reach out to our parks and wildlife folks here in the city to see if they know of anybody who's accepting prairie dogs. So that's the first step in management that we require. Second is that if there is not a place to relocate them, which over the last, if I say more than 10 years, we haven't had anybody with a site who has said that they're taking prairie dogs, then the next step is to contact the Black-Footed Ferret Recovery Program or the Raptor Rehabilitation Program here in the state of Colorado. We have 2 places up, one I think both are up near Fort Collins. It actually does rehabilitation and trying to build up the numbers for the black-footed ferret for reintroduction into the wild, and they use the prairie dogs as a food source. So what they do is they actually have to hire a wildlife company that goes in and live traps them and then euthanizes the prairie dogs in a way that they can then be fed as food to either the ferrets or to the raptors. Now that gets expensive because they can't just use any kind of substance that they may be approved for extermination. They have to specifically kill them in a way that's not going to harm either the raptors or the ferrets. So as an example, when we had the area that was developed next to Lowe's, where we have the Les Schwab tire, the gas station, and the Guardian storage, that applicant spent almost $18,000 to live trap those, to kill them, and then have them transported and given to the organizations that then use them for food. So it's not a small number for them to do that because somebody has to be out there all day while those traps are there because they can't leave them sit for too long in the traps either. They're trying to do it in a humane way. They're not trying to leave them sitting out where they can't get out and get protection or not sit out in the sun. So it is a process. Finally, and this happens occasionally and usually after, it seems after Longmont has had an area where we have had a large number of prairie dogs captured and donated, occasionally they will tell us that there is no more room in their freezers right now. They are full. And when we get that documentation, then we allow for someone to hire a licensed exterminator in the state of Colorado to go out to their property and exterminate them in whatever method is approved by the state. So that's a 3-step process that we require for all development. So when we do our pre-application conferences, that's part of the things that we're looking at is we're trying to determine, are there any prairie dogs on the property at the time they come in to talk to us? And if so, that's the steps that they have to go through. Now, there is no restrictions currently, and I don't know whether or not there'd be interest in it, but currently you have the right as a property owner to maintain your property. So if you are living near an area where there are prairie dogs on someone else's property, they migrate across the road, which happens almost every so many months as they continue to breed and have their pups. They kick out the young ones. They go find new places. You have the right as a property owner to exterminate them on your property. The only time that rule kicks in is when you make a development application to us and you have prairie dogs on your property. So there is a lot going on, and I understand that some people would like to see us set aside land and require that prairie dogs be left on the property, and that's their that's what they believe should be done. And there's others who feel the complete opposite of that. You know, a couple of examples from past history of what has happened was Xilinx originally had set aside land down along the creek, down along their southwest side of their property, and they actually relocated prairie dogs off of their original property and moved them down there and then exterminated the rest. Now, a couple things we've learned since that time, because that was back in like the early 2000s, was that one, you don't want to put them in a floodplain, because that doesn't usually let them last long with the first flood. Second, you need to make sure that where you're relocating them, there's adequate habitat. You know, that you can't just move them to an area if there's not food source for them that they can eat. You know, you may have great intentions of creating a spot, but if there's not adequate food or the right kind of food there, they'll leave anyway. So they're not going to stay or they're going to die. The other was that the city had relocated and put a colony down on Sandstone Ranch by the ranch house, down by where one of the oil wells was drilled. That was damaged during the drilling of one of the oil wells. The dogs escaped. They did a lot of damage in that area down along Sandstone to the habitat down there. And then the other was that once we tried to relocate some of the city out to the airport, and that turned into a not very fun time with the FAA when you have prairie dogs digging holes next to the runways, that if a plane went off and a wheel went into one of the holes, you could have significant damage or death. So we had to, unfortunately, remove the prairie dogs that we moved out there. So, you know, we've tried different instances. Brian might know some others, but that's just an example of what we look for right now, what's required. And so that's just what's going on there. And then the other, oh, yeah, go ahead.
So if you don't mind me indulging for just a few more minutes, I'll just hit a few bullet points with respect to the riparian setback. So in 2005, the city adopted a wildlife management plan. A year or two later, we incorporated some of the recommendations from the wildlife management plan into the land development code, and that's where the 150-foot setback requirement came into place. And that's not, it's along St. Vrain, but it's also along Dry Creek, adjacent to Union Reservoir, as well as Left Hand Creek. But there are provisions for modifications to that 150-foot standard, dependent upon whether or not there is the presence of habitat in that area, what the current conditions are, what the current width is of that corridor. So there are currently options in the land development code to make modification to that 150-foot standard. Obviously, pre-flood, we had embarked on what was called the St. Vrain Blueprint, and a couple of the speakers mentioned that. It was looking at opportunities, not only the kind of the environmental and recreational opportunities along the Greenway, but also kind of economic development, redevelopment opportunities in some areas where back in the 50s and 60s, a lot of the industrial buildings had turned their back to the river. And, you know, we're looking at opportunities for enhancements to that corridor and try to create some like redevelopment along the St. Vrain Creek as well, taking into consideration and not discounting the desire on the part of the community to protect the environment and wildlife along the corridor as well. And then the flood happened, and now we have the Resilient St. Vrain project, which obviously has started the first phase over by Martin Street and the Dickens Farm Park. And you can see all the vegetation that's being removed as part of that project. And we also have our sustainability plan that was recently adopted as well. So all those things are kind of playing into as we relook at the land development code, and this section in particular, how it ties in with the Resilient St. Vrain project and the St. Vrain Blueprint, we're looking at that particular section, and we'll be bringing that back to the commission for your discussion and consideration, and obviously we'll get input from the public as we go through that process. But, we want to look at options and bring some options back to the commission for consideration and discussion, and whether or not, 150-foot citywide from end to end makes sense, or maybe we look at some different options along the length of St. Vrain, urban versus rural. And so those are just some different considerations that will be taken into account as we look at those.
So that is something that you've already have planned long-term to come in front of us?
Yes.
Okay. Commissioner Height, your mic is on. Do you have?
Yeah, all I was going to say is Brian just touched out when Ms. Bowman, Ms. Malloy, and Ms. Simeon spoke. Instead of talking about this 150-foot riparian setback, I went and found where the code provision is, which is 1505020, which does exactly what Brian says. There's a setback for it's St. Vrain, Boulder Creek, Dry Creek, Union Reservoir, Left-Hand Creek, and then it's 150 feet, and it's 100 foot from all other wetlands, with the opportunity for the planning director to increase or decrease based upon riparian factors. So it's not just discretionary, it's ordinance.
Okay. Commissioner Goldberg?
Yeah, and just continuing down this topic, I want to thank Commissioner Teta for acknowledging that we had 3 guests come before us today. As Commissioner Height mentioned, Ruby Bowman, Sherry Malloy, and Jamie. I didn't catch her last name, CMAO or something like that. That's how change happens, is when the public comes and gets a robust discussion like this going. And you were heard, and we appreciate that. And it sounds like we'll have more of this discussion in the future.
I would like at this time to welcome Commissioner Check. Welcome aboard, and good job on your first time.
Thank you.
Any other items from the commission? Items from Don Burchett, Principal Planner. No items. That means we can move to adjournment.